Workers join unions for many reasons, including higher wages, better health and accident benefits, contractual provisions that ensure a safer workplace, greater job security, and a voice in the workplace. Let's take a look at the history of labor relations. Skilled craftspeople were the first workers to unionize. The first unions in Sweden were formed by printers. In Great Britain, the first unions were formed by building and printing trade workers. All these unions were formed because the people in these trades were concerned about the competition they faced. In some trades, the ability of skilled workers to move from one location to another affected wages within their industries and led to the formation of local unions. The local unions prevented tradespeople from other parts of the country from coming into a certain locale and bringing down wages. Since the early days of labor unions, strikes have been used to achieve unions' objectives. Workers who continued to go to work during a strike became known as scabs, and their names were shared among local unions in an effort to ensure that they were not employable. Union members refused to work with non-union members, and would even refuse to interact socially with them or live in the same boarding houses with them. By 1873, union membership had reached 300,000 in the United States. By 1878, however, membership was down to 50,000 due to the Depression. Then, in 1886, the American Federation of Labor, the AFL, was formed, and unionism began to increase once again. Still, it wasn't until about 1933 that unions became firmly entrenched in the manufacturing sector. This helped fuel an upturn in union membership. A pro-union president, Franklin Delano Roosevelt, and new legislation made it easier for workers to unionize and played a major part in this upsurge. In 2015, union membership in the United States reached a record low of 11.1%. This percentage was the lowest recorded by the Bureau of Labor Statistics since they began collecting the data in 1983. In 1983, union membership rate was about 20.1%. Many reasons exist for this decline in union membership. Globalization has resulted in many traditional union jobs being moved to other countries, with manufacturing particularly hit hard. As manufacturing has moved abroad, U.S. job growth has occurred in the services sector and the small business sectors, and other sectors of the economy that have historically been less likely than others to organize. Add to that the reluctance of local unions to spend money on organizing efforts, something that has traditionally been their responsibility, and you have a recipe for decline of union membership in the United States. This decline is not just, however, a U.S. phenomenon. Critics of unions say that employees don't support unions today because they're able to individually reap the benefits unions used to provide them. Data from the Bureau of Labor Statistics suggests otherwise. For instance, in 2014, union members were paid on average $970 per week compared to $763 for non-union members. This spread of 27% has remained fairly constant since 2000, when the Bureau of Labor Statistics started tracking this wage data. Union members typically pay 1 to 2% of their salaries to their union. That's a small price to pay relative to the benefits members reap. This legislation was followed by the passage of 3 acts: the Wagner Act of 1935, the Taft-Hartley Act of 1947, and the Landrum-Griffin Act of 1959. Jointly, these 3 acts are referred to as the National Labor Code. Prior to the 19th century, 5 laws had been enacted to handle rail labor disputes. Nonetheless, labor unrest in the railroad industry continued. Violent strikes and lockouts interrupted rail transportation of people and goods in the United States, adversely affecting the economy. The Railway Labor Act, or RLA, was passed in 1926 to try to provide a peaceful way for railroads and their employees to resolve their disputes. The RLA applies to common carrier, rail service, and commercial airline employees, the latter of whom were included in the Act through provisions passed by Congress in 1936. Congress passed the NORRIS-LAGUARDIA Act in 1932 to make it easier for employees to engage in union organizing activities. Before the passage of the act, employers had all the power when it came to how workers were treated. They could have federal courts issue injunctions in cases involving or resulting from labor disputes if employees wanted to strike or otherwise interfere with the flow of work. The act also outlined the process to be followed for hearings, granted workers the right to collective bargaining, and stated that neither officers of a union nor the union itself would be held liable for unlawful activities of its members that could not be proven to have been instigated or approved by the union. Congress subsequently passed the National Labor Relations Act, the NLRA, known as the Wagner Act in 1935. This act is often regarded as the most important piece of labor relations legislation. The act was passed for three main reasons: to protect the rights of employers and employees, to encourage these parties to engage in collective bargaining, and to control their activities so the economy wouldn't be adversely impacted. The Wagner Act established the National Labor Relations Board, known as the NLRB, to oversee compliance with the act. The NLRA protects private sector employees from employer and union misconduct, such as attempts by employers to prevent unions from organizing and attempts by unions to coerce employees into joining them. The NLRA also ensures that employees have the right to organize a union where none currently exists. The specific rights provided under the NLRA to employees include the following rights: to form or attempt to form a union at their workplace, to join a union even if it's not recognized by their employer, to assist in the union organizing effort, to engage in group activities, collective bargaining, such as attempting to modify their wages or working conditions, and finally, to refuse to do any or all of the above unless a clause requiring employees to join the union exists. The NLRA also provides rights to employees who are not part of a union. These employees have the right to engage in concerted activity. Concerted activity exists when two or more employees act together to try to improve their working conditions, or when a single employee approaches management after conferring with other employees on their behalf or is acting on the behalf of other employees. Unfair labor practices, known as ULPs, are violations of the NLRA that deny rights and benefits to employees and can be a result of an employer or union's activities. Such violations include threatening to take jobs or benefits from employees who attempt to form a union, reassigning workers to less attractive jobs than their current ones if they're involved in union activities, and telling employees they will receive greater benefits if they don't join a union. Labor unions violate the NLRA when they tell employees that they will lose their jobs if they don't join a union or maintain membership in the union, when union employees are on strike, or bar non-strikers from entering an employer's premises. Specifically, Section 8 of the Act defines the following ULPs. First, interfering with, restraining, or coercing employees in the exercise of their rights guaranteed under Section 7 of the Act. Dominating or interfering with the formation or administration of any labor organization or contributing financial or other support to it. Discriminating against employees in terms of their hiring, tenure of employment, or any other term or condition of their employment so as to encourage or discourage them from becoming members of a labor organization. Discharging or otherwise discriminating against employees because they file charges or give testimony under the Act, and refusing to bargain collectively with the duly chosen representatives of employees. Although the Act identified these practices as unfair, it did not make them crimes nor impose any penalties or fines on people or organizations for their occurrence. 26 states have passed right-to-work laws to prevent workers from having to join a union as a condition of employment, be forced not to join a union as an employment condition, or be forced to pay union dues to a labor union, or be fired for not paying such dues. Organizations such as the National Right to Work Legal Defense Foundation and the National Right to Work Committee work to ensure that these rights of workers are not violated. The role of the foundation is to work through the courts to support individuals who have been victims of forced unionism. The committee lobbies state legislatures and Congress to eliminate forced unionism and works to educate people about right-to-work laws. Regardless of whether a state is a right-to-work state, the Taft-Hartley Act has led to safeguards for workers who do not wish to be forced to become union members. The most extreme form of union membership is a closed shop. A closed shop requires workers to join a union before they can be hired and requires employers to go to the union first to hire new employees. Only if union employees are not available can the employer recruit non-union employees. The Taft-Hartley Act generally outlawed closed shops and ended the right of unions to decide who could be members of the union. Under a union shop agreement, all workers except managers in an organizational unit represented by a union have to become members of that union within a certain period of time after being hired, or at least pay the equivalent of union dues. This type of agreement is referred to as Union Security Clause. Union shops are illegal in 29 right-to-work states. Under an agency shop agreement, employees cannot be required to join a union, but can be required to pay a union an amount equivalent to initiation fees and dues that are considered to be a tax or service charged and are referred to as an agency fee. In exchange for these payments, the union acts as the bargaining agent for the employee. In reality, workers who are not union members can only be required to pay an amount equivalent to reduced union dues solely for the purpose of supporting the collective bargaining, contract administration, and grievance resolution services the union provides. The types of unions have evolved over time and include local unions, city and statewide federations of local unions, and international unions. Local unions later joined together to form city and statewide federations. Statewide federations joined together to form national unions, and many of these now have become international unions. Local unions protect the interests of workers in a particular craft or trade or industry. Its members are in the stationary, skilled building maintenance trades. Member dues are used to pay for worker representation and collective bargaining efforts and are set through a vote of union members. Today, the lines between craft unions and industrial unions are blurring, but there are still some distinctions. Craft unions are organized to represent the interests of members with specialized craft skills. Industrial unions have traditionally represented semi-skilled and unskilled workers in particular industry. Local unions are a voluntary association of workers who have band together because of their shared economic interests. They might work for the same employer or the same several employers. In any case, the members recognize that the union provides them with a greater voice with respect to their employers that they would do alone. Each member is entitled to one vote, and decisions are made by a majority vote. Elected officers and executive board are empowered to act on behalf of the union. Members remain in good standing as long as they pay their dues and other required fees and follow the guidelines of union membership. After a local union is organized at a company, the union elects a union steward to serve as a liaison between the rest of the employees and the leadership of the union. The union steward is an employee of the company who serves in the role voluntarily. Typically, the formal agreement between the union and the employer will specify the role of the union steward, including the amount of work time that the steward can spend on union activities. International unions are federations of local unions. In essence, an international union is a parent of local unions. Workers are members of the local union rather than the international union. However, the local union pays dues to the international union. International unions hold regularly scheduled conventions in which delegates from local unions participate. The international union elects officers and an executive board from among these delegates. International unions provide services to local unions that would be more costly or difficult for them to provide individually. For instance, the Federation is in a better position to lobby for legislation on behalf of local unions than are individual local unions. When a group of employees decide they would like to be represented by a union, their first step is to file a petition with the NLRB. Employees in a designated work unit, referred to as the bargaining unit, provide a dated signature on either a union authorization card or a signature sheet, indicating that they are interested in being represented by a particular union. At least 30% of eligible employees must provide this card for the NLRB to consider the petition. The NLRB then assigns an agent from an appropriate regional field office to process the petition. The regional office of the NLRB holds a secret ballot election, usually at the workplace. A majority vote in favor of the union is all that's required. The NLRB then certifies that the union represents the employees for collective bargaining purposes and requires their employer to bargain with the union. Here's an overview of the steps required in the union certification process. Step 1. Workers decide they want to be represented by a specific union. Step 2. 30% of eligible workers in the bargaining unit sign cards petitioning the NLRB for secret ballot elections. Step 3. A representation certification petition is filed with the NLRB. Step 4. The regional office of the NLRB holds a secret ballot election. Step 5. The NLRB tallies the vote to determine if a majority of workers voted for the union. Step 6. The union is certified and the vote is positive. Step 7. The employer is required to bargain with the union. One of the most challenging parts of the certification process is determining who is actually eligible to sign the card. The bargaining unit can consist of workers in a single location or from multiple locations. The bargaining unit can also be limited to a specific group of craft workers or a single department. The NLRB determines who is eligible to be part of the bargaining unit, or the union and the employer jointly make this decision. Regardless of who makes the decision, the company is required to supply the NLRB a list of names and addresses for employees who are eligible to vote in the representation election within 7 days after the NLRB has indicated that an election will be held. An Excelsior list is a list of names and addresses the company must supply of employees who are eligible to vote in the representation election for a union. Guidelines exist for what employees, employers, and union organizers can do during a unionization attempt. Employees can lobby a body of coworkers to vote in favor of the union, but they can only do so during lunch and other break times. The employer gets to decide where the union literature can be distributed by employees. Employers also can require employees to attend company meetings so that management can present its view about the union being formed. These meetings can be held on company premises and during work hours. However, no meetings can be held in the 24 hours immediately preceding the election. Supervisors are permitted to have one-on-one meetings with employees about the union issue and can give employees written information as well. Union organizers work for unions and are not company employees. These organizers are not allowed to campaign for the establishment of a union on company property unless the workplace is remote, such as a logging camp. Organizers can distribute information in public areas, at the work location, or in public areas of the city. They can also call employees and visit them at their homes. Federal law does provide an alternative route under which a union can be recognized by an employer outside the NLRB process. Employers can voluntarily recognize a union if employees show majority support either through signed authorization cards or some other route. When the employer voluntarily recognizes a union as the bargaining representative for a group of employees, the status of the union cannot be challenged for a period of 6 months to 1 year after the first bargaining session occurs. A card check is a process whereby a company recognizes a union once the union has produced evidence that a majority of workers have signed authorization cards indicating they want the union to represent them. Under a neutrality agreement, a company agrees that it will not express its views about unionization during the time when signatures are collected. Unions preferred card checks and neutrality agreements because the NLRB does not become involved in the union certification process and management loses its right to speak out about the possible effects of unionization. Collective bargaining is the process that labor unions and employers use to reach agreement about wages, benefits, hours worked, and other terms and conditions of employment. The NLRB requires that employers and unions bargain in good faith. Good faith bargaining requires the parties to meet at a reasonable time and come to the bargaining table ready to reach a collective bargaining agreement. Mandatory bargaining topics must be negotiated and include compensation and benefits, hours of employment, and other conditions of employment. Pensions, insurance, grievance processes, safety, layoffs, discipline, and union security have also become mandatory bargaining topics. The law does not require an employer and the union to actually reach agreement on the topics, only that they bargain in good faith. The bargaining process also includes issues such as employee rights, management control, and benefits for retired union workers. However, these topics are not mandatory and are referred to as permissive topics. With the fast-changing global economy, job security has become a critical component for collective bargaining. No measures can be discussed that would be unlawful. Actions that constitute bad faith bargaining include bargaining with individual employees rather than union representatives, refusing to meet at a reasonable time to engage in bargaining, and going through the motions of bargaining without the intent of reaching an agreement. Other activities that may or may not be considered bad faith bargaining include not being willing to schedule enough bargaining sessions and applying economic pressure to the other party. Let's take a look at the steps of the collective bargaining process, including being prepared, knowing the interests of the other party, and understanding the consequences of not reaching an acceptable agreement. Both parties involved in negotiation, labor and management, spend considerable time preparing to negotiate. It's important that each side have a current and accurate data to address the topics for negotiation. Being prepared means entering into negotiation with some idea of what the other party will expect with regard to the final outcome. Understanding the interests of the other party, what the other party sees as critical relative to the outcome, puts the negotiator in a stronger position to bargain for concessions. Two commonly used types of negotiation strategies in labor negotiations are distributive and integrative bargaining. When a distributive bargaining strategy is used, there's a winner and a loser. The goals of one party are in direct conflict with the goals of the other party, and often each party wants to claim a fixed set of limited resources as its own, or at least maximize its share. Each party takes a defensive position during the bargaining session. In an integrative bargaining strategy, each party is more cooperative and works to make an outcome with a win-win result. In this situation, one party can pursue its goals without precluding the other party from doing the same. Both sides cooperate to reconcile their differences and reach a mutually agreeable solution. Interest-based bargaining, known as IBB, is basically an extension of an integrative bargaining solution. In this situation, each party looks for common goals in order to meet the interests of the other party. Brainstorming, information sharing, and other techniques are used to ensure that the lines of communication between the two parties are kept open. The goal is to reach consensus so both parties can win. What happens if the parties to a union negotiation can't reach an agreement? Often, the result is either a strike by workers, a lockout of workers by managers, or arbitration, with a third party making the decisions. The situation in which both parties have made their final offers and are not willing to make further concessions is referred to as an impasse. When an impasse occurs, the parties have several options. First, an impartial outside party, such as the Federal Mediation and Conciliation Service discussed earlier, can be called in to facilitate the negotiation. This facilitation can take the form of conciliation, which involves keeping the parties working on the agreement until they can resolve the issues at hand. The facilitation can also take the form of mediation, which involves the outside party working with each side to reach an acceptable agreement. Finally, arbitration can be used to resolve the issues. Unlike conciliation and mediation, in which a third party acts as an intermediary, arbitration involves a third party actually making the decision about the issue. Employees and unions also are using arbitration to resolve their disputes with individual employees. Grievance processes are the formal steps that must be followed to settle disputes between labor and management. The grievance process typically works as follows. First, the problem is reported to one's immediate supervisor, who is obligated to investigate the matter and try to resolve the problem. The report can be written or oral, but it's usually written. The supervisor should then work with the union steward to resolve the problem. If the union steward does not believe that the problem is a legitimate grievance, no further action is taken. If these effects do not result in a resolution, it goes to the next level of supervision. At this time, the employee filing the grievance is represented by the union. Failure to resolve the grievance at this stage within the time allotted in the collective bargaining agreement, usually 5 to 15 days, result in the grievance being taken to a higher level of management, such as a plant manager or even the executives of the organization. This highest level of resolution then is obligated to make a decision as to what should occur. At this stage, the company and the union are both represented by high-level managers and union officials. If the union contract calls for binding arbitration, and most do, the arbitrator has the final say in the case. If the grievance is still not resolved, the final step of the grievance process is to call in an arbitrator who will review the facts of the case. The employee's right to have a union representative involved in the process of disciplinary hearings resulted in large part from the 1975 landmark U.S. Supreme Court case NLRB v. Weingarten, Inc. In this case, the Supreme Court ruled that a union representative could be present when a supervisor conducted an investigatory interview to gather information that could result in the employee being questioned or disciplined, or when an employer asks an employee to defend his or her actions. As a result of this case, managers have to notify union representatives of the purpose of the interview. In addition, the employee has the right to select which union employee will be present. Managers need to be very familiar with the requirements of union contracts and understand the types of actions that can lead to grievances. By doing so, they reduce the likelihood that they'll have to participate in a grievance process. If a grievance is reported, the proper care and handling of it is critical. Conducting a fair and timely investigation, keeping your supervisor informed, and carefully documenting all activities relative to the grievance are just a few ways to minimize the likelihood of a grievance going to an arbitration hearing. A grievance is a charge by one or more employees that management has violated their contractual rights.